The battlefield just shifted under our feet. Picture this. A state passes a law that tells Washington to back off, that it will protect its own people, its own gun rights, and its own reading of the Constitution. That's exactly what Missouri did. Then the Supreme Court dropped a hammer. Not a whisper, not a delay, but an emergency order. 8-1. No middle ground. Every red state with a similar law just felt the blast wave. The Second Amendment Preservation Act, once the crown jewel of state-level resistance, is now on life support. The DOJ has the green light to come in hard. What flipped? Why did the feds sue? And what does this emergency ruling mean for your rights next year? We're breaking down the court's message, Missouri's misstep, and how this one case is already rewriting the map for gun owners nationwide. Stay locked in. This is the full picture. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. Section 1. Missouri draws the line. Back in 2021, Missouri lawmakers didn't just tiptoe into the gun rights debate. They slammed the door on federal reach. The Second Amendment Preservation Act, SAPA for short, declared that Missouri cops could not help enforce any federal gun rule the state deemed unconstitutional. The law hit departments with fines up to $50,000 if their officers lent a hand to the ATF or DOJ. In plain English, Missouri told the feds, "You're not the boss of us." Other conservative states took notes. SAPA became the blueprint for nullification 2.0, the idea that states can erase federal authority inside their borders. Gun rights rallies cheered, fundraisers boomed, and copycat bills started moving in places like Arizona, Wyoming, and Tennessee. But while the fireworks lit up the stage, the Department of Justice was already loading its own cannon. Constitutional scholars warned that SAPA wasn't just policy. It was a direct challenge to the Supremacy Clause. When a state starts punishing its own police for cooperating with federal agents, the turf war gets real fast. Missouri had thrown the first punch. Washington just waited for the right moment to counter. Section 2. The DOJ counter-punch lands. That moment arrived in February 2022. The DOJ filed suit in the Western District of Missouri, and the opening brief was a throat punch. Their argument was simple. States cannot nullify federal law, period. SAPA, they said, crossed the line from passive non-cooperation into active obstruction. The complaint listed 3 ATF investigations that died on the vine because local departments refused to run traces, share files, or even answer phone calls. One case involved a felon stockpiling AR pistols without serial numbers. Another centered on a straw purchasing ring tied to 2 Kansas City homicides. Federal lawyers framed SAPA as a public safety hazard, not a philosophical debate. They quoted the Supremacy Clause, the Commerce Clause, and a line of precedent going back to the 1950s desegregation cases. The message: if Missouri's model spreads, the entire architecture of federal firearms enforcement could unravel. The district judge agreed. In August 2022, he issued a preliminary injunction, freezing the heart of SAPA. Missouri appealed to the 8th Circuit, but the Supreme Court was already watching. Section 3. SCOTUS drops the emergency order. January 9th, 2024. Cold enough to frost the Capitol Dome. Without warning, the court issued an 8-1 emergency order denying Missouri's request for a stay. No oral arguments, no full briefing, just a concise, unsigned opinion. The lower court's injunction stays in force. SAPA is effectively dead. Justice Gorsuch stood alone in dissent, arguing that the court should at least pause the injunction while the 8th Circuit finishes its work. The other 5 conservatives plus the 3 liberals formed an unusual alliance, sending a crystal-clear signal. Federal law still reigns supreme on guns. Red state attorneys general read the tea leaves within minutes. If the court wouldn't throw Missouri a lifeline, their own copycat bills were suddenly radioactive. SAPA's defeat wasn't just a loss for one state, it was a warning shot for the entire nullification movement. Section 4. Inside the gutting. So, how did the DOJ dismantle SAPA so completely? They focused on one explosive detail: the $50,000 penalty. Federal lawyers argued that Missouri wasn't merely opting out, out. It was holding a financial gun to its own cops' heads. Choose the feds, lose your house. That, the government said, is textbook obstruction. The district judge bought it. His ruling froze 3 core parts of SAPA. 1. The private cause of action fines against police. 2. The ban on state employees aiding federal gun tasks. 3. The declaration that certain federal statutes are invalid in Missouri. Police chiefs who had hidden in the tall grass suddenly issued memos. We will resume cooperation with ATF task forces. Within weeks, trace times dropped, joint drug and gun indictments ticked up, and federal grants once on hold began flowing again. SAPA's armor had been peeled off, plate by plate. Section 5. The domino effect. Missouri wasn't lonely for long. At least 5 states, Texas, Arkansas, West Virginia, Alaska, and New Hampshire, had passed watered-down SAPA clones. Within days of the Supreme Court's order, their AGs started pumping the brakes. Texas announced it would pause enforcement pending further review. Arkansas legislators promised a rewrite to strip the financial penalties. West Virginia's governor quietly rescinded an executive order that had directed state police to stand down during ATF operations. Police unions added pressure. No department wanted to risk the next $50,000 lawsuit. Federal agencies, sensing the tide, reopened joint task force offices that had gone dormant. The nullification wave crested and rolled back in real time, leaving gun rights activists scrambling for a plan B. Section 6. New York hits the accelerator on red flags. While red states backpedal, blue states are flooring the gas on gun controls, and New York just rewrote the red flag playbook. Effective March 2025, anyone from a roommate to a coworker can file an extreme risk petition online. Judges can issue a temporary order the same day, no hearing required. Once the ink is dry, police are authorized to confiscate firearms immediately. The target may not know the order exists until the knock on the door. The new rule shrinks the timeline from days to hours, and the burden flips. You have to prove you're not a danger, not the other way around. Critics call it star chamber gun seizure. Supporters call it suicide prevention. Either way, the pace is unprecedented, and copycat language is already circulating in Illinois, California, and Washington state. Section 7. The $200 NFA stamp is on life support. For 90 years, the $200 tax stamp has been the toll booth to own suppressors, short-barrel rifles, and other NFA items. Now that gate is creaking open. Bipartisan bills in both chambers would remove suppressors from the NFA entirely, arguing that Europe sells them over the counter for hearing protection. ATF processing times, already north of 12 months, have turned the tax into a de facto ban, something lawmakers say violates the Second Amendment under the 2022 Bruin Standard. States like Texas and South Dakota have preemptively waived any local tax on NFA items, betting the federal stamp is on its way out. But here's the catch. Even if the tax disappears, registration and serial number tracking stay. Forget to file the right form, and you're still looking at a 10-year federal felony. Freedom on the surface, strings underneath, the bureaucratic spiderweb remains intact. Section 8. Colorado's new training gauntlet. Starting January 1st, 2026, Colorado will demand every concealed carry applicant sit through a state-certified in-person class. No online course, no military exemption, no grandfathering. The curriculum covers legal liability, de-escalation tactics, live-fire qualification, and a written test. Miss one box on the checklist, and your application is toast. Proponents call it responsible gun ownership. Opponents call it a poll tax for carry permits. Either way, the state just seized control of the training market, and prices are already climbing. Other swing states like Nevada, Minnesota, and Pennsylvania are watching the experiment. If Colorado's law survives court review, expect mirror bills in 2027 legislative sessions. Section 9. The retroactive ban wave. Imagine waking up to learn the pistol you bought legally 5 years ago is now contraband. No grandfather clause, no buyback, just prison time if you keep it. That's the reality unfolding in Illinois, New York, and California. The new statutes list specific rifle models, magazine capacities, and even adjustable stocks. Own one, and you're a criminal the moment the governor signs the bill. Enforcement varies. Some departments vow door-to-door sweeps, others wait for traffic stops. But the trend is clear. Retroactive bans are the new frontier. Courts have yet to rule on whether such laws violate the Constitution's ex post facto clause. Gun rights groups promise appeals, but for now, owners face a stark choice. choice: turn it in, sell it out of state, or risk felony charges. The playbook is simple. Erase decades of lawful ownership with a single vote, then dare the courts to stop it. Section 10. Lawful carry as probable cause. A quiet but chilling shift is playing out in federal courthouses. Simply carrying a gun, even with a valid permit, is being used to justify searches and prolonged detentions. The logic goes like this: officer safety outweighs your Fourth Amendment rights. If a cop sees a holster during a traffic stop, that's objectively reasonable fear, allowing a pat-down, a vehicle sweep, even a K-9 call. Some rulings stretch further, claiming the mere presence of a lawfully carried firearm creates exigent circumstances. Gun owners find themselves handcuffed on the curb while officers rummage through glove boxes and phone data. The courts are split. The Fourth and Fifth Circuits have greenlit the practice, while the Sixth and Ninth have pushed back. Until the Supreme Court weighs in, every permit holder is one aggressive cop away from a roadside fishing expedition. Closing. The landscape for 2026. Add it all up. Nullification is dead, red flags are lightning fast, training gates are rising, retroactive bans are spreading, and lawful carry is being recast as suspicious behavior. The target isn't the street gangbanger. It's the accountant who shoots USPSA on weekends, the mom who carries in the grocery store parking lot, the veteran who keeps a bedside pistol. Each new rule sounds reasonable on a press release. A training hour here, a tax stamp there, but stacked together they form a maze with ever-shifting walls. One wrong step and you're a felon. The only counterweight is information. Read the bills, track your state house, know your local DA's policy, and vet your training options before you need them. 2026 isn't just another election cycle. It's the year gun laws mutate in real time. Stay informed, stay equipped, and keep your circle educated, because the next change won't come with a warning shot. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.